So we're already in session, and we're looking at the revision of 53507, which is the obtaining healthcare consent for minors and adults. And there are several other policies that I think if we get this one, the rest of them will probably not be as difficult as this one. But in taking into consideration, is Kelly Eifert here? Ms. Tissot?
I'm here.
Here you are. Hey, how good are you? Kathleen Warthen? Any of these? Okay, so we're just going to go through these, and Lori, we're on the first page of what I sent to you, and the writing in red is what the staff sent out for revision. Although there were some things that were revised that were not in red, but we'll get to that in a minute. In the highlighted section in yellow, Tricia Harrison added other health care services funded by Medicaid to the purpose. And I imagine the reason for that was, what was the reason for that, Tricia? Do you remember?
I'm going to have to catch up.
Okay. It just says other health care services. I'm assuming there are other health care services that might be added at some point or that might not be defined as medical diagnostic care.
Well, in CDS has taken the position that the services they get are not medical services, although they've been funded by Medicaid.
Okay, so health care services. Does anybody have a problem with health care services being added? Lori?
No, I'm fine with that. I wanted to ask one question about the title document. Is now an appropriate time?
Yeah.
Okay. Yeah. Obtaining healthcare consent for minors and adults with intellectual disability, related disability, which includes autism. I mean, there are many folks with autism who do not have intellectual disability. Is that, I mean, is it necessary to word it this way because of our statutory authorization, DDSN's statutory authorization, or I'm just wondering why is it worded that way?
I don't know, but we can strike out which includes and put and.
Yeah, that's what I would do.
Well,
okay.
It is defined as a related disability in the statute.
Okay.
So that's just consistent.
Well, if that's the case, but
this is our direct.
Because it says intellectual disability / related disability, which includes autism, and I just want to make sure it's clear that there are many people without intellectual disability who have autism.
Why not put intellectual disability and related disability?
But I mean, and is also fine with me. You know.
I just take that slash out.
It's fine.
Okay, so we're going to take out. So we can do intellectual disability and related disability, or we can do intellectual disability / related disability and autism. Does anybody have a preference? Okay, then we'll do intellectual disability and related disability, which includes autism. But you just said, well, no, that's related. Okay. Okay.
I just want to clarify number 5, the one that was added by Ms. Harrison. Are you talking about our residential program and our day programs? Are you saying that those are health services?
Certainly PCA services, residential services, all those are health services. Otherwise, they're not covered by the Adult Health Care Consent Act. And they're funded by Medicaid.
The definitions of healthcare is in the statute.
We just took the definition out of the statute. What we're trying not to do is expand the statute because we didn't write the law. So
we're not trying to write a law. We're just writing.
That's right. So we just pulled out. So we just pulled out the definitions that are in the law and moved them into here. We can't expand that.
Well,
I don't think we have the authority to expand it.
Are you saying the law doesn't include healthcare services?
These are all healthcare services. What they're trying to say is that we have got folks that when we go to, it's hospitals and doctors and actual medical care. It doesn't get into all that other. That stuff's covered under their planning process.
Look at page 2 at the bottom. It has healthcare as described in the Adult Health Care Consent Act. Healthcare means that procedures are diagnosed or treated these ailments. So
it's in there anyway.
it's in there.
Okay, moving on. Under philosophy, highlighted is unless one of the following criteria is met. That was added by Kelly Eifert to say that legal guardian has been appointed, and a power of attorney has been executed. Which now this was a change by Kathleen Worthen, we had a durable power of attorney was executed, and she changed it to a power of attorney has been properly executed which relates to health care, and the authority to consent is within the scope of the power of attorney.
That's fine.
It's fine. That's fine. We don't see any problem.
Okay.
So this is Lori. Can you hear me? I
Yeah.
lost the Skype. Okay, I lost the Skype connection, so I've dialed in by phone now. Can we just move the clause which relates to health care to after power of attorney? So it says a power of attorney which relates to health care has been properly executed, and the authority to consent is within the scope of the power of attorney.
Yeah, move has been properly executed to after which relates to health care.
Yes. Thank you.
Okay. Sure. Okay, moving on. In the center of the page, Ms. Eifert wanted to change the word intelligent choice to informed choice. Going to the next page. Ms. Eifert wanted to add physician assistants to the list of healthcare professionals and also to healthcare providers. But that makes sense since adult advanced practice nurse practitioners are on there, so physician's assistants would be on there also. Now the last four were added by Ms. Harrison, and that would be licensed psychologist, physical therapist, occupational therapist, and licensed speech therapist. And I believe they are considered to be healthcare professionals. Some definitions of providers would not include them, but they are healthcare professionals.
So my question there, this is Lori again, is in that case, whether board-certified behavior analysts should be added. Certainly, I know in my own son's situation, I would trust his board-certified behavior analyst. He has more of a relationship with them than he does with a PT, OT, or speech therapist.
Mm-hmm.
And they're not licensed in South Carolina, but they are authorized by the laws of this state to provide health care services pursuant to the autism insurance mandate. So I raise that for your consideration.
Statute said they're supposed to be licensed or certified.
Or
Well, they are.
otherwise authorized.
Are they certified nationally, Lori?
Nationally.
Yes, they're nationally certified.
There's some other providers of mental health services that are also not on this list if it's going to go that direction.
Right.
We need to
And we were relating to the folks that would be, basically, we're talking about qualified staff members of DDSN or the board. So it's not related, I mean, only if they are working for the boards or for DDSN is what this was applying to.
Well, DDSN employs board-certified behavior analysts or contracts with.
Yeah.
Dentist or not.
Yeah.
Okay. Well, let's just add board-certified behavior analysts.
Maybe I also, that dentists, I think, used to be in the list or not in the list.
Should be, because
They're not, they are exempted from this. There's a special thing about dentists under this.
So they were taken out for that.
Mm-hmm. I'm not sure why, but yeah.
Because they would certainly be licensed.
Okay, well, we don't have time to research it, but why they were removed.
Is there a clause that removes the?
Yeah,
the
I can find it,
specific-
right, yeah, something here, but it was just,
Can we also
Okay.
add a comma after DDSN where it says for DDSN, DSN boards, and DDSN qualified providers?
Yeah.
Okay. Okay, at the bottom, reasonable accommodations will include but not be limited to using technology devices. This whole sentence was added by Ms. Tissot, I hope I'm saying that right, of Able, South Carolina. and it relates to something that comes up a little bit later. But reasonable accommodations, she defines as will include but not be limited to using technology and devices, receiving assistance with communication, having additional time and focused discussion to process information, providing tailored information oriented to the comprehension level of the alleged incapacitated individual, and accessing services from community organizations and governmental agencies. So we want to define reasonable accommodations because she refers to it again later. And then supported decision-making, she added the process by which an individual with disability uses designated supporters to assist in explaining information, weighing various options, and communicating decisions to the extent needed by the individual. The supporter does not have any authority and services only to assist the individual making informed decisions. So we'll go ahead while we find those and look at why that's important. Under unable to consent,
They're not, this is not in the code. And again, the person making the healthcare decisions are going to be health professionals, and they're not bound by this.
okay, so comment number 10, unable to consent, and highlighted in yellow, is reasonable accommodations will be made to ensure one's capacity to make and communicate responsible decisions regarding their health care. So we can put in there whether a physician in a hospital is bound by it or not. We can put in our policy that it is our position that reasonable accommodations be used.
I think the position is, that's more of a procedure that we would use to make sure that the person has reasonable accommodations to try to understand their medical care. But it is not part of the statute. And the doctors don't have to do all that.
Everything in here, this whole policy is filled with things not part of the statute. So, I think it's a good idea to go on record as saying we would like to have reasonable accommodations available to people who are able to make their own decisions. Lori.
I'm in favor of that. I mean, as much as I've, kind of been able to think through the ramifications, you guys tell me if I'm not thinking it all through, but reasonable accommodation seems like a good policy for our agency.
I think it's especially important for people with disorders like cerebral palsy, where they have mental capacity, but if you Zoom through a plan meeting, you're not going to get input back.
Right.
Also a federal law under the Americans with Disabilities.
It is.
Oh, yes.
Thank you.
Oh, yes.
Okay, so moving on then. Initial process. Yes, sir. Yes, ma'am.
Supported decision-making,
Yeah.
I don't think we talked about that. If a person doesn't have capacity to choose a supporter or supporters, then this is all not appropriate. I've been submerging myself in records recently where persons with 2 to 5 year old mental capacities have been, with the help of the people in the house, making decisions. So I think supported decision making can only be appropriate where the person has the capacity to choose the supporters. And if you have a group home with nothing but the staff at the home, which is usually the case in making a plan or getting health care, that's a violation of HIPAA and the adult health care consent.
So we're not going to be able to solve that today because we're not going to be, but supported decision making and reasonable accommodations, I think we need to go on record as at least taking that step because it is part of choice.
Wait. I'm sorry. Can you explain? You think we need to go on record as what with regard to
As offering what we just decided to do, which is providing, yeah. So in the initial, go ahead.
I was just going to say, I mean, I'm in favor generally of the concept of supported decision-making. What I'm not sure about is whether just dropping it in the definitions of the Adult Health Care Consent Act is the way to effectuate supported decision-making. Is there anybody there who's, got some legal opinion on what is the ramification of just, I mean, all this
Where
is a
in
list of
particular are we
definitions.
talking about?
The supported decision making, she's talking about that.
The last one.
Under definitions?
Mhm.
Okay, well, if we don't like, if this is a definition, we put it in there to kind of outline what it is, and where we use it later on is where we'll have to be careful. We're just defining it
Okay.
as best we can in this, but it's not, when we get to that where Ms. Tissot put that in there, then we can tweak it there if we need to.
My concern is ensuring that the supporters do not have a conflict of interest. If you go back to
Yeah.
the amendments that were made to the 2016 Adult Health Care Consent, and look at what the committee was looking at, one of their concerns in the drafting of amendments was conflicts of interest. And so,
Well, let me tell you what some people, one comment made to us was that we don't need to do anything except say that we'll go by the law. That's what mental health does. And she said everything else is just confusing. I fundamentally disagree with that, because if we don't put some guidelines in here, then it's left up to individual interpretation, and we've seen where that's gotten us. So, I mean, we need to do the best we can. We're not going to be able to make everybody happy here, but we do need to do the best we can to make sure that people who can exercise choice are able to do that, and we're moving in that direction. It's not perfect, but we're going to have to move in that direction at some point in time, just to make sure we have something in place to try to enable people who can make their own choices to make their own choices.
I think your comment, the persons who have the capacity, is really important. And I think it should say the process by which an individual with disability with capacity uses designated supporters. Because if you have a person with an IQ, what's going to happen is you're going to have the people at the group home making decisions, and they're going to use to support the decisions that they made when that person had no capacity to choose his supporters, and the supporters are the ones who are choosing services that profit the board, not necessarily the services that the individual needs.
Okay, Lori, on that supported decision-making policy, the process by which an individual with a disability with capacity uses designated supporters.
Okay.
Sam?
I'm just wondering if the whole idea of this supported decision-making just opens a can of worms that goes, I don't know, it seems to muddy things. I understand the idea, and I'm in favor of everybody having whatever help they need to get the proper decisions made, but I'm just wondering if
What extreme measures people will have to go to make sure they carry that.
also, a lot of times the way people read directives is they'll see supported decision makings and take that as a must.
And this is an alternative to guardianship. It's true that people need guardians, and that's not always the case.
Is it a legal alternative in South Carolina right now?
So with the new guardianship statute that's coming in January, there is mention of supported decision-making in that statute. So that is coming along, and the intent of that new statute is definitely supported decision-making.
So-
And,
and
we are going to be introducing legislation in the next session as well for supported decision-making to be
Okay,
recognized.
but it's not passed yet. It's not law yet.
So starting in January, that new statute will take effect.
It has to do with guardian, how you appoint a guardian.
But that doesn't have anything to do with the Adult Health Care Consent Act.
So
Right.
none of this
And like
federal
1%
stuff has nothing to do with
of people
adult.
may be
No, it doesn't.
considered.
It doesn't have anything to do with the Adult Health
Yeah.
Act.
Okay.
And that was
I mean,
kind of my point earlier.
Right, and as we look at, a lot of this is procedure, you're exactly right. How do you do this? To encourage people to develop that circle of supports, that's in our person-centered planning philosophy, and that's where it needs to start. I don't know if this is the, or maybe in the body of the document when we start talking about bringing folks together to help somebody make decisions. And I have seen people with very low IQs be able to make decisions in certain areas of their life. So I wouldn't say that somebody with a low IQ precludes them from making a decision about certain things. They might not understand every aspect of, what this treatment will do, but who does? I mean, honestly, we all ask for help when making these decisions. So if we encourage, that kind of process.
So what I want to do is keep going until we see that in the policy and see if it's appropriate.
Okay, gotcha.
Okay, so in the initial process, Mr. So recommended that we take out typically the staff person who is responsible for developing the service support plan, the ICF. What is that? What is that? Was it
Interdisciplinary team.
Or cross that out and put the healthcare provider will raise the question. Her comment was the medical provider and not a service coordinator should raise the issue of decision-making capacity for medical decisions.
Yes,
What
and it should be
statute
done
says,
on
yeah.
an incident-by-incident basis. Just because you can't make a decision about one thing doesn't mean you can't make a decision about a lot of things. I mean, talking about cancer treatment, which is super complicated, versus, I've seen dentists want consent to get someone's teeth cleaned. That is that is a decision people can understand versus I'm going to want help making a decision about cancer treatment. So I think that we also have to watch that. So
Can we go back up to, let's go back up to unable to consent because I skipped over that one.
Mm-hmm.
Highlighted, reasonable accommodations will be made to ensure one's capacity to make and communicate responsible decisions regarding their health care. And Tricia Harrison recommends that capacity consent be determined at the start of services.
No, I can't agree with that. Just for the reason I just said. Because if we just say you're not able to make decisions, that means everything that you do from this point forward, you won't be able to make a decision about. And that inhibits someone's rights to make decisions on the things they can make decisions
If that's
about.
providing the accommodation, you're not going to know what their ability is.
That's a
Well,
lot.
maybe Patricia Harrison meant at the start of those particular healthcare services, like the dental cleaning or the chemotherapy. What is that?
The start of what services? The start of our services or the start of an individual?
I didn't see you sitting there.
Medical care. Medical care.
I just kind of crept in because, yeah.
You did.
But not in this area of life.
No, the lawyer in the room is great. That's why we need more lawyers in the room.
It's like a child in school. If a person has a mental capacity of a 4-year-old, it's like a child in school. You can't pick when we're going to get a consent from the parent. If the person has a mental capacity of a 2-year-old or a 4-year-old, you can't decide, I'm going to decide this person can consent to this. It's like a child in school.
So the problem that I have with it is that capacity changes for us, for other people. So if we want to take a look at the intake policy, and, maybe we can do that later, but for now, I'm thinking that this is going to be, as Sam would say, a real can of worms, because there's going to be if this and if that, and, so.
But,
I think it's like Mary said, I think that was Mary talking, it's at the initiation of the particular healthcare service at issue. So like my son with Asperger's was taken in for a blood draw recently. He's 11 and he refused consent to the blood draw. But he doesn't refuse consent to teeth cleaning. So it's on particularly if the healthcare provider is the one determining the incapacity or the refusal to consent, or it says the healthcare provider will raise the question of a person's ability to give valid consent for healthcare. So if the healthcare provider, then by definition, it is on a healthcare service by healthcare service basis.
Yes.
So do you want to put in there capacity to consent will be determined at the start of the healthcare service?
That works for me. I mean, I think that, yeah.
You can't have staff. For example, I have a case pending now where the staff decided the person with the mental age of a 40-year-old could consent to sexual training, sexual responsibility training. You can't have an individual who has the mental capacity of a child signing any consent.
Right. Presumably, a healthcare provider would recognize an inability to give valid consent for a particular healthcare service,
and they do. As a person who's done this for many years, they do. They stop the process. They want that person to either get some help making a decision, or they say we need someone to consent, and then we go through the process. But if you took out the just the sentence unable to consent with at the word manner, stop there, don't add another sentence, you cover it in the next one where it says the healthcare provider for each individual event would make that decision. So you're not just blanketing the person for the rest of their lives coming into service as you're not able to consent for anything. And it's the same thing for training. I mean, I do understand that people have what they call a mental capacity of a 4-year-old. I don't use those terminologies anymore, but I do know that a 40-year-old man has the body of a 40-year-old man, and he has he's a man, and I don't ever think of him as a child at that point. But I think that here, you do it in this next sentence. That sentence says it really nicely. It says that each doctor will, for each different thing.
Well, the unable to consent decision that it ends in an ambiguous manner is exactly quoted from the statute.
And so the next sentence.
Yeah, I think the additional sentence was just added, presumably, to ensure that reasonable accommodations would be used. And so whether that sentence is necessary there or is taken care of elsewhere.
Well, it ties back to that. That was the whole point of doing reasonable accommodations.
But again, we're saying it's the doctor, the healthcare provider, that's going to make the reasonable accommodations, and we have no control over that.
By law, he's supposed to.
That's right. It's his law. This is about him.
Right.
Yep.
But what we can do as staff is ensure that if my son is going to the doctor, that he has his alternative communication device with him so that he can have a reasonable accommodation. He can make use of his accommodation in conferring with the doctor.
So I guess it's not the sentence we're objecting to as much as saying we don't want to add another one saying that it'll happen before when services start. That we want to keep it where it is. True?
Yes, because it's healthcare.
It's healthcare.
Right.
Aren't we addressing this though down under the initial process
Yeah.
when healthcare is proposed, valid consent?
That's right.
Yeah, I mean it seems like we're already taking care of that.
And what we're not arguing is the sentence that is there. We're just saying that the comment doesn't need to be added. That we're not going to talk about it prior to. That we're not going. When someone comes into services, we're not going to sit there and decide that you are not going to have able to consent for your health care. And then we'll do it per service.
Because we don't make that determination. Doctors make that determination. Healthcare providers, not people engaged.
The reality is when a person comes in and staff beating their knee and they're getting an X-ray,
There are potential issues.
the doctor isn't going to say, "Oh, do you have capacity to consent to this X-ray?" But the parent needs to know what happened to that individual. And I'm seeing cases where parents for years don't know about hospitalizations, don't know about emergency room treatment.
That's not this.
Right, that's not.
That's a different issue.
Kimberly, because I forgot, sorry. Kimberly, what do you think? You added, it was your comment. Reasonable accommodations will be made to ensure one's capacity to make and communicate responsible decisions regarding their health care and unable to consent. I don't think that's too much to ask.
No, I think
That's good.
I've got one more comment, sorry, but I completely agree with the sentence, reasonable accommodations will be made to ensure, but I don't know that it belongs in the definition, or I ask for consideration of whether it belongs in the definition of unable to consent. definitions should be just definitional
True.
rather than instructing DDSN what we're going to do, i.e. offer reasonable accommodation.
And it is taken right from the statute.
Yes, where I said where it stops
Right where
in
it
an
stops at
ambiguous
manner.
manner, that's exactly what the statute says.
Well, it relates back to capacity, though. We don't know what their capacity is unless we supply the reasonable accommodation.
And one of the reasons why we put that in is because reasonable accommodation is forgotten. It's assumed they're not trying to communicate with them properly. They're missing communication devices.
Right.
And so we feel as an organization that it's very important to keep reminding people that sometimes people communicate differently and require. And again, going back to the ADA.
I mean, I agree with the substance of what you're saying. Again, I just question, you don't
Right.
load up the definitional section with things that are operational rather than definitional, or that's my opinion.
No, I agree, and to say, we might want to expand on it. Remember you said during the body of it, when we're actually applying this directive, that we are going to use the word reasonable accommodation there.
Well, we haven't left definitions yet. We're still on
But
definitions.
you know what I'm saying? So why would we expand the definition when we know we're going to use it in the body of the actual directive?
And I would agree with Lori. Anytime you're talking about definitions, it helps to keep them clean.
I agree.
All right, and the last sentence, the capacity consent will be determined at the start of the healthcare service. In or out?
Where's that
Well,
sentence? It looks like it's just a comment.
So
Was,
Somebody
and I
made
made
the
it.
point that that's already in initial process, where it says when healthcare is proposed, valid consent must be obtained prior to initiation and implementation of the healthcare.
That's
Isn't that
correct.
the same thing Tricia was asking for?
I think what the implication was that when the person comes into services, we make that determination right then and there.
The doctor makes that.
Well, the determination is made at the beginning of services, and that is,
The start of the
Again.
healthcare service to be,
and that would be entering a residential program?
Well, it should be any service because you're having incapacitated people sign
No, it's
plans of
healthcare.
behavior.
This is
This is
healthcare.
healthcare.
And
This
the
is
doctor
healthcare.
can say this person has
Expanded it
the capacity
by leaving in
to
that
make decisions
other
about
healthcare stuff.
minor health routine matters,
That's right.
but he needs assistance, and maybe the doctor can make that determination.
all right,
The agency needs to know that at the start when they come.
all right, we're about out of time, so we're gonna have to move quicker in order to just get one policy. So,
I'll say something.
do you wanna take, Lori, do you wanna take out that sentence and just say that it's addressed other places?
Yes, I would leave the definition of unable to consent exactly as it is in the statute and address the reasonable accommodations and the initiation at the start of the healthcare service within the operational part of our policy.
All right, and the next sentence on initial process, the healthcare provider will raise the question and cross out, that's those things that are crossed out according to Tussaud's suggestion.
Yeah, that's fine with me.
Okay.
Hey, can I raise, and I know you don't want to go back, I know you don't, but
No.
I think we have to.
I don't know if we do have time to
On
go
the
back.
purpose, on the front page, when we added other healthcare services funded by Medicaid, is that entire, the statute has 1 to 4, and we added number 5?
Yes.
Was
Okay, so with that put in place, that gives us an issue that has just put all our programs and everything else in play for this directive, which was not the intent of this
Right.
directive. This law says this is about healthcare. This is about going to the doctor. This is about getting an x-ray. This is about getting cancer treatment. This is about getting all that stuff done. And we've just added
I don't think
this.
it does if you look at the definition of healthcare.
I think that it might open that doorway.
Then do we need to take that healthcare definition out too?
I think we just need to leave it what the law said it
What
was.
the law says,
Law
yes.
says those are 1 to 4 is what the law says. This is a directive that talks
That's not what the law says.
about the law.
This is what we
This is the health-
have as healthcare
Right.
in our services.
Mhm. So adding that then puts it into where you do have to say, well, you don't have the capacity to ever make a decision about anything you do. You're going to need mom and dad or somebody else to do that
I don't
for
think
you.
I don't think that's what it says at all.
I think that's opening a door that we don't want to do that because it takes away the rights of individuals. To me, I think it's discriminatory. I think
do we know why Tricia wanted that added?
My problem, Lori, is that I'm seeing the individual with, and I'll give you the example of the IQ of 36, who is sitting around with staff from a house, and they are choosing to give only congregate services and not give other services that he needs that cost the board money. So that is health care. And the parents or the family members were never informed about the plan meeting. The families are not given copies of incident reports. The parents are not told when the individual goes to the emergency room. In one case, the individual was in a hospital for 3 days.
Oh, yeah, it is.
Or the sister wasn't informed. So I believe that the determination needs to be made when the person comes into services, and a person with a mental age of a 2-year-old does not have capacity to agree to a plan of care. The family needs to be involved in that plan of care.
If you look at the definition of health care, going back to what Deborah suggested, I think about 45 minutes ago, health care means a procedure to diagnose or treat a disease, ailment, defect, abnormality, or complaint, whether of physical or mental origin. It includes the provision of intermediate or skilled nursing care, services for the rehabilitation of injured, disabled, or sick persons, and includes, if indicated by this directive, the placement in or removal from a facility that provides these forms of care.
Well, we provide habilitation, not rehabilitation. To be perfectly frank, that's what's in the Medicaid waiver.
Well,
and actually, it's a real definition issue because we actually were providing the individual rehab supports, and it came back to say that when you don't do rehabilitation, so they actually took that service away. So it is a tiny difference in a definition. And in ICF's, nursing care is provided. So I think that's why they're included. This nursing care is part of the scope.
Let's see if we can get through a few more. Comment 13.
I got a question though. I mean, it seems to me like we're if you keep other healthcare services in there, then it seems to me you're going to have to go back and change the definition of healthcare because we don't define what other healthcare services are. I just think to leave that on there as some kind of catch-all is not in line with statute.
Particularly
and the definition of healthcare.
And
particularly
a lot
the
of the
intent
things
is
that Ms. Harrison's
the
talking about
Adult Health
are
Care
covered
Consent
in
Act up
other
there.
directives, and if we have incidents of that happening, then they should be mitigated at the incident.
Lori,
Yeah.
committee gets to vote here, so appreciate all the other comments. Well, Lori?
Yeah. No, I mean, I don't know who's talking at all times, so I'm a little bit.
That's Chris.
Chris was talking,
Well,
Lori.
I knew that was you, Chris, but so I mean, I don't disagree with the reason for adding the other healthcare services, but I do think we ought to stick to the statute, the statutory definition of healthcare, but address this through a different directive. I mean, if there's not one that directs that addresses it currently, then we could have a new one. So I guess that's my thought.
Okay, Sam, take it out.
That's my thinking, yeah.
All right, going back to number 13. Kelly Eifert added, and the person must be provided any needed augmentative or communication devices, technology to assist in that dialogue. Again, this just goes back to supported services.
I'm sorry, where are you reading from right now, Vicki?
Comment 13 is below initial process and into assessment of ability to consent, page 4.
Okay, got it.
All right, so this goes back to reasonable accommodations. And she just added, the person must be provided. If you read that whole sentence, it's just logical.
Yeah.
That we
I'm
put
good.
that in there.
I'm good with
That
that.
falls right in line with the reasonable accommodation.
Right, and on the next page also, even with reasonable, the whole thing is just repeating it again. or communicate his or her decision in an ambiguous manner, even with reasonable accommodation and support, then the person is suspected unable to give consent. So we're just adding that reasonable accommodation in there. JD, who is not here, said, you can speak for her, okay. An individual may designate supporters to assist them in understanding information related to their health care consistent with the supported decision-making model. Which,
Down with doctors again.
Can I ask a question here?
yeah.
So again, I'm in favor of supported decision-making. I'm glad to see South Carolina incorporating that into statute and policy. Somebody mentioned earlier that it will be part of statute that becomes effective in January. What statute is that a part of? Because I'm only questioning whether the Adult Healthcare Consent Act is the appropriate place to embrace supported decision-making as a concept.
It's a change, Tana, it's a change in the guardianship through probate court.
Okay.
They're going to be looking a lot more at allowing folks to have basically more limited guardianships to make sure that they're not taking away everybody's rights to make all decisions. It's going to be on the ability of the person, what ones they can make and what ones they can't make.
Got it. Okay. That makes sense to me.
Okay,
go ahead.
Also, though, clarify those that are assisting do not have a conflict of interest.
And
That's my only, that would be my only.
That's the difference. You've got a probate judge who's not making money off the decision, or who's not going to be sued because the person is getting that health care x-ray because the staff hit his knee. So with the probate court, supported decision-making is a totally different issue.
Okay,
You have staff deciding who's going to be giving.
All right, all this in it says is an individual may designate supporters to assist them in understanding information related to their health care, consistent with the supported decision-making model, understanding the conflict of interest situation that we're not going to resolve today. So it just says an individual may designate supporters. I don't see that we should have a problem with that.
Again, it's not in the code under the Adult Health Care Consent Act.
And so the next comment, number 16, would be from Ms. Tissot. If two physicians, based on their examination, and she added, and knowledge of accommodations and support available to the individual, determine that the person can consent, then the person shall give consent for him herself. Neither physician will be employed by DDSN or DDSN contracted. That was a comment added by Tricia Harrison. Lori.
Can somebody talk to me about what happens in practice today?
Well,
is it typical that it's a DDSN employed physician?
In the community, no, because most of those we just use who's available in the community. But at the regional centers, there's a director, there's a medical director, and that's the person's primary care physician. So if you say this doctor can't help in this decision, the person who knows them best, you're saying that you're actually being discriminatory against that person. They can't even have their own doctor do this, help them make this decision. Am I saying that correctly?
Right, correctly.
Correctly. And then we go to a stranger, and then the other doctor would be the person that's probably doing the procedure.
Yeah.
So if you're having a surgeon, they're the ones that are going to raise the issue of consent first. Actually, it's going to be the anesthesiologist, if you want to know about practice. The anesthesiologist is going to say, this person can't consent. I'm not doing this.
Sam.
And then they
Okay,
will. Right.
enough. Sam?
What she said.
Lori?
Well, are there people in the room who can kind of make the argument on both sides? I don't
Well,
know.
we're running out of time, and we're really close to getting this thing wrapped up that we've been working on since it was screwed up last year by staff.
For example, Tan Platt has
Right,
been
but
the
I mean,
medical director.
can it be
was the
two
medical
DDS?
director for many years
Not tolerant of
at Babcock Center.
But I mean,
And we all know what went on there, and he testified that he's never seen
outside
abuse
the
there.
system.
So when you have a person who's paid by that board making a decision about the capacity I think there's a conflict of interest. I think at the start, it's ridiculous to me to think that a doctor, every time he sees a patient, he's going to take the time to decide whether this patient is competent to have this procedure done or not. The decision needs to be made with a focus on that person's capacities and not based on a 15-minute procedure. I mean, if a person has the capacity of a 2-year-old, he will never be able to give consent. And we need to let the parent or the representative know every time that person has a healthcare procedure. And what's happening is that is not happening, and parents and families are only finding out after something horrific happens. And I don't think you or I want our relatives to be in that position.
Well,
I agree that parents need to be informed, but is that part of a different policy?
Yeah. No, they're having people with clear lack of capacity to consent, so the parent never knows the person's been taken to the doctor 12 different times for injuries. The parent never knows because they're not getting consent from the parent. If they were getting consent from the parent would say, why is this person supposedly falling all the time at the residential placement? He doesn't do that at home.
A potential solution could be.
Go ahead.
A potential solution could be, since 2 physicians have to be involved, one could be the physician at, let's say, one of the centers, but then an outside physician that is brought in to consult and be part of the process. So you have one internal, one external, and the 2 physicians together make a decision.
But it could be difficult to get an outside one sometimes. I mean, it depends what the healthcare procedure is. It's not going to be a surgeon. It's not going to be something else. I mean, think about it. If you have to go, you have your primary care physician, and then if it's something else that they usually take care of, you're not going to go outside and find somebody else to do it as well. There could be another healthcare professional that works at the center that could do the same type, make that same type thing, because they're the people that know the individual.
Yeah, I disagree. I mean, I think you have to have someone else outside the system. I think there is a conflict if you've got 2 internal physicians making decisions. I agree on the one,
Eva.
But I think you should have someone else externally that's working with
Would
that
you be
physician.
okay if we had, of the 2 physicians, one has to be not involved with DDSN?
Yes, I think that's a good compromise.
It just seems like a good compromise, because it addresses Mary's concern, but then you have an outside.
But I'm just going to tell you that when you're doing these things, you are usually you're consulting with another physician outside. So it's not a hard thing to do.
Right.
All right, so down below that, if the 2 physicians not employed by DDSN, we can put one of whom, not employed by DDSN, based on their examination, that the person cannot give consent. Same thing, Chris?
Yeah.
The person designated and authorized to make decisions from the person-supported decision-making agreement. Okay, if no agreement is in place, Ms. Eifert wanted to take out authorized person and put personal representative. Was that Kelly or was that Tricia?
I think I did that.
That's not defined in the code.
Yeah.
This part.
We need to stick to the
It's
definition.
authorized person.
What is that?
Personal representative.
We have to use
The federal
common
code
languages in statute.
supersedes. That's what's used in HIPAA. So the federal law supersedes the code, and it's called personal representative.
Lori?
I don't have sufficient familiarity with the 2 statutes to know. I'm sorry. I mean, I'm looking at the statute, the Healthcare Consent Act right now,
Being consistent.
and I don't.
And it refers to authorized person all the way through the statute.
We need to be consistent.
Gary?
I agree. That it needs to
Sam.
be
Yep, I agree.
All right, we go back to authorized person. Okay, comment number 21. Again, the same thing. We go back to authorized person. 22. Ms. Harrison, the person is considered to be able to give consent. If the two physicians disagree, we have crossed out the person is considered to be able to give consent and put in the probate court should become involved.
That's not in the code.
Yeah. Is the person considered to give consent?
The code does not address what happens if the two physicians disagree.
Oh my, what do we do if we don't in the code?
Makes sense.
You can't just pick one.
Well, you can get another doctor, get a second opinion. You would do that if you.
Well, you got two involved now.
Right, and they're saying if one disagrees, but the code doesn't
Yeah,
address
I
what
read
happens.
that.
Mm-hmm. Well, wait a minute. I'm just thinking this through. What the policy of the statute does is if two physicians determine this person to be incapacitated, then they're incapacitated. If two don't determine that, then they're not incapacitated.
I think that's what it's supposed to be saying, yeah.
I mean, so it seems to me, I don't even know why we have the sentence, if two physicians disagree in there, because they either both give consent or they don't.
Right.
Mm-hmm.
All right, so strike the whole thing?
Yes.
Yeah.
Sam.
Yep. That is true.
Okay, personal representative, and go back to authorized persons, and the last page, skip 2 over. Kelly Eifert suggested that we put the Attorney General's letter of opinion, attach it to this policy, because technically we're not in the current statute at all, other than by a letter of opinion from the Attorney General. So I don't have a problem with attaching that. Do you, Sam? Lori?
No, good idea.
Okay, and then the last paragraph, 25, last one, y'all. Tricia Harrison, when there is more than one person with priority, the form that delegates authority should be signed by the person with priority saying that she does not wish to exercise that authority, and identifying for the case manager who is next in line. And 2, if there are multiple people with authority, an attempt will be made to say that if they can all agree to delegate their powers to one person with a backup if that person cannot be reached in the time necessary. If the majority of persons of the same party cannot agree, the probate court needs to become involved.
Just for 30 years, I've never seen this happen.
Right.
But,
I'm wondering if the solution to this is take this out, but when, as the legislative committee, Lori, you and Chris, that y'all get with Tricia and come up with something reasonable, and that you try to get whatever you want in that law to eliminate this conflict of interest problem, but do it by law instead of by this policy.
I mean, I'd certainly be willing to work on that.
Chris?
That sounds like a plan.
Tricia?
I'm perfectly willing to work with whoever's interested. Just what I'm seeing on the ground, which a lot of y'all didn't see, is parents having no idea, and the house manager picking a relative who is not the person with authority, and not even doing a search to find who is the person with authority. And that puts this agency and the board at risk of litigation. But I'd be happy to work with them.
Thank you. I appreciate all the work that has gone into this, and the compassion and trying to get it right. And the next thing we want to look at is cameras. We probably will have to have another policy committee meeting, Lori, maybe you and Sam, and I can get on the phone and knock some of these things out, even if we have to spend a couple of hours, because we're backing up because of this Adult Health Care Consent Act policy. But we have made it, and what I want us to do is, Susan, make all the corrections, send them out to the committee, make sure we got it the way it was, and then maybe at the next meeting present it to the full commission.
would the committee entertain a recommendation to the full board that we begin to develop a pilot project at the Coastal Center with the use of cameras? In other words, to go ahead and start getting our bids together and actually start the development of a policy and get that agreement from the full board that this is something that we're going to, would you entertain a motion to
I
let
think
us
you ought to
move ahead
bring
with
that up to the full committee.
I think we had that coming out of your committee, but that's fine.
I think we're not
I can bring it out of my
able to
executive director's
debate
report.
at 30 seconds. Yeah.
Okay, I'll do it out of there.
Hey,
That's
that-
It's on the,
it's not on the agenda, so that was coming out of here. It's on your agenda.
Okay, so
So
it would need to come
the-
to the
what's
full
on-
board out of
we
here.
have a,
yeah.
well, what I want us to do is have another meeting. We're late as